by scaling up our perspective from local legal operations to international legal frameworks. Our second panel discussion is titled Regulation, Data Protection, and AI Governance, South Asia in a Global Frame. And to lead this, I would like to welcome on stage Mr. Anthony Alex, founder and CEO of Rainmaker, who's also the moderator of the session for us. Let's have a huge round of applause, everyone, in welcoming Mr. Anthony with us. Next joining us is Mr. Debasish Roy Chowdhury, General Counsel and Head of Legal, Compliance and Secretarial, Insolutions Global Limited. Our next panelist, ladies and gentlemen, is Ms. Shivani Peesapati, Director, Cybersecurity Lab at GE Healthcare. And finally, Mr. Yogesh Naik, Senior Legal Counsel at Volvo Group India. Let's have a huge round of applause, everyone, for all our panelists.
Thank you very much. Absolutely delighted to be here, and I was just chatting with our panelists about how time is so flexible in India, where the networking break, everybody's having chai, coffee, chatting, but that's good because that's what makes these kind of sessions so meaningful, right? You get to really interact and get to meet a lot of people. So thank you all for being here. Thank you to my fellow panelists as well. So we'll kick off the sort of conversation, and I wanted to maybe just throw the floor open to all of you and hear from you. We have the DPDP Act now. I mean, I think the two buzzwords in India these days, wherever you go, especially amongst lawyers, I think you have AI, which was the previous panel, and then you have DPDPA, which everybody is talking about. So I want to sort of just get all of your views. The Act was passed a couple of years ago. Now the rules have sort of brought it into force. What do you all see as the sort of fundamental challenge in operationalizing this law for each of your respective organizations or your sectors? It's now in force. Of course, there is the 18-month period which started in November last year, but it's very much in force and operationalized now. But the government has also given staggered timeline for organizations to comply. So if each of you could just share from your perspective, from your industry, from your organizational perspective, how, let's say, a challenge that you see in your sector in sort of, fully complying with the law or operationalizing the law or getting compliant, that would be sort of a great way to kick off our session. So maybe, Debasish, would you like to go first, or Shivani? I'm happy with whichever way you'd like to start.
I can go ahead. I'm Shivani. I lead the cybersecurity team within GE Healthcare. I'm not a lawyer. I'm a technologist. So, I'm here to learn from the lawyers in this group. But as a technologist in the healthcare sector, which is one of the most critical sector within the technology domain, right? So maybe I'll talk about what does it mean for us in DPDP and what is that one big challenge that we have. It's a good thing for us because we care for the patient, we care for the safety of the patient, and that patient is not somebody whom we have not seen. It is one among us. It's our own family members. So with the growing cyber attacks and everything that's going on with AI, it's important that we have such laws in our country as well. Even though with the little knowledge that I have, IT Act was also still covering some part of the privacy, but this is a stricter law and it has more things covered, right? The one big challenge that healthcare as a sector is having is the integration between the manufacturer of the devices or the solutions and the provider, which is the hospitals, the diagnostic centers and all. The government has come up with certain platforms. They have given the contract to certain platforms who will actually work on the software that will talk about, or that will come up with the software which will talk about what is the permission that, what are the things that we will ask you, your personal information, and for that permission from the patients, right? The problem is healthcare is a very in India, basically, healthcare is spread across different dimensions. There are these huge corporate hospitals which can buy any software, any platform, if it is needed by the law. Then there are these small diagnostic centers which cater to health, small X-rays and ultrasounds and all, which cannot afford to buy if the software is too expensive, right? And then there are these mid-tier, and then there is government supported PHCs, the public healthcare centers. And the DPDPA actually brings in even the public healthcare centers into the gambit of the law, which was not the case with IT Act, right? So with all this in mind, what is that platform that we will integrate with? How that end-to-end workflow will happen? How a patient can go ahead and remove his consent from the consent management platform. And overall, with AI also coming in, we doing federated learning at the hospital atmosphere so that data is not going out. That is a challenge for us. How exactly we'll work? What is that particular consent management platform that we want to integrate with, which will be common for us? And how that design would be. And it needs time, given that everybody is working with in their own pace. But we will also have to work with all these tiered customers of ours. Since I come from an organization which is a global organization, we've already complied with GDPR, we've already complied with HIPAA and other laws in Canada, Singapore, or Japan. So complying with the law is one part of it, but this consent management is one of the biggest challenges for us. And that is what we are working on as I speak.
Wonderful, thank you for sharing. I think it's definitely, we don't have enough insight into how the consent manager framework is actually going to work in practice. So that is still something that is evolving. So yes, fair enough. Debasish?
Yeah. Thank you, Anthony, for this question, and thank you, LexTalk World, for this wonderful platform. So Anthony, I'll just break it up in terms of the first phase, and then probably how I come from a fintech industry.
Yes.
So basically some of the areas where we are kind of grappling with at this point of time, and where we are seeing that we have to make a lot of kind of structurings and stuff what we need to do just to have that DPDPA fully enforced from our organization's perspective. See, so the act was promulgated in August 2023. So when the main act came, but if you see this entire process, it's been a fragmented kind of an implementation what the government of India is doing. This entire DPDP Act. As you have rightly mentioned that from November 2025, 13 November 2025, if I'm right, they have given 18 months kind of a promulgation of this rules implementation and all, which probably is going to be further reduced because they are now planning to make it in next 1 year by December this year and all. That's what you are planning. Now, if you see, like when this act was enforced, most of the organizations started thinking like, how am I going to kind of put my documentations in place? Because the act was talking about your policies, you're talking about consent management, it was talking about notices, it was talking about breach frameworks and all. So the first half of 2023 to 2025 late and 2026 beginning, most of the organizations probably who were not having the GDPR applied to them, probably as she has rightly mentioned, if some of the organizations with GDPR already kind of applicable, so they had a much better structure and formats in place. But most of the organizations started focusing more on the documentation part, the policies, the rules, how you put that in the website and all those things. Now what is happening from the documentation part, the things are now going into implementation part.
Correct.
Okay. Now, so most of the organizations now talking enough of documentations and enough of it. The legal department, the risk department, they have done their work. Now it has to be an organization-wise responsibility. Right. And when I talk about organization-wise responsibility, it has to have the involvement of the HR team, the InfoSec team, the IT, the business, the marketing, everyone. And I'll obviously during the course of my session, I will say like how they are going to be involved. So the moment it shifts from documentation to implementation part, then some of the real wordings or real questions starts happening. The first and foremost question which every organization now at this point of grappling with is the data mapping. How do I do the data mapping? Okay, so see, at the beginning or at the initial stage, for a fintech company also, we have taken data's right, left, and center. Okay. We said, okay, fine, take now and do all those things, mapping and all those things later. Now the real question of mapping has started. And the moment you talk about mapping, so mapping basically has to be, first and foremost, you take the data, and the question of data processing comes. Next to important aspects comes whether you have a consent framework, that's the first thing. And if you have a consent framework, the second thing which comes is that whether it is falling within the legitimate purposes, which has been defined in Section 7 of the DPDP Act. Now, if you talk about the consent framework, then you have to see in what way that consent was taken, whether it was a coercive or it was a plain, simple way and all. So all these questions comes in. And the data is what you are talking about. The next question comes whether it is coming under legitimate purposes or not. Because see, the Section 7 is defining some of the exceptions in terms of, say, if you take employment data, specifically for human resource, by human resource team and all, that forms probably potentially come under the exemption, legitimate purposes. If Government of India or some regulatory authorities ask for some data and all, that will come under that. So those questions have started emanating now. So that's the first part.
Correct.
The second part is the data breach processes and compliances. I think in my earlier, in the earlier session also someone is talking about the 6 hours, the 72 hours norms and all. So if you see the current norm, so I think as far as certain is concerned, they tell you you have to give that data in 6 hours. But DPDP Act has given two kind of directives, first immediately and then probably in 72 hours. So that data breach notifications, obligations, that's something what companies has to practically implement now, which they were basically more of discussion nature, which was there earlier. Now they have to think from that perspective. Third thing, the most important aspects, and I'm saying all from my organization's context, and this is something what we are grappling with, is in terms of how the data localization kind of things are happening, because we have a lot of financial data and all those things. We have global subsidiaries and other things and all. But see here, on not only the DPDP Act comes into picture, there are RBI master circulars are also getting applicable for us, because RBI specifically said in a master circular dated June 2018 that financial data and all you cannot transfer, irrespective of what what are the other regulators or other bodies come in. Right. DPP board is yet to come in. A data protection board, we are yet to see the light of the day as far as the DPP board is concerned. So that's another challenge. So considering these 3-4 major challenges, so at this point of time, when as a fintech company, I'm trying to develop a product, what is the consent management framework I'm putting in? What kind of KYC structures I'm putting in? Any fraud risk management or any other kind of AML kind of structures what we are trying to put in. So the moment we are developing a product, we have to see that we try to embed that thing by a design process rather than taking it
privacy by design and ensuring that
Absolutely.
It's all part of how you're designing.
Absolutely.
Okay.
And that is something what the government of India is also now coming in. They've come out with a very recent concept which is called code to compliance. Like the moment you do something, that code should include all those compliances, the privacy by design or AI by design or whatever, the digital structure by design. So at this point of time, I just like to end on this thing is that we have moved from the documentation to the implementation part. Most of the organizations, our organization, including FinTech, where we deal with a lot of sensitive data, a lot of voluminous data in terms of credit card, debit card, and all those information. So you have to be very mindful how we are using those data, because only single mistake here and there might cost the company dearly. And thirdly, we have moved away, like DPDP Act is very clear about digital personal data. It doesn't talk about sensitive data, confidential data, or critical data and all. So you have to be very mindful of that fact, and you have to do our processes and implementation based on that. Unlike GDPR, who has bifurcated this.
Or even unlike the prior versions of the draft
Absolutely.
that we have seen.
Absolutely.
They've done away with all that, and now it's just digital personal data.
Absolutely.
Yeah.
So these would be my initial comments, and happy to
Sure,
hear
sure.
from others.
Thank you. Thank you, Debasish. Yogesh would love to hear from you.
Yeah. I'm Yogesh, Naik, Senior Legal Counsel from Volvo Group India. We make trucks, buses, and construction equipment. We also make cars, but that's a different company of ours. So moving from healthcare, fintech, and to automobile sector. So DPDP is a big kind of a law, which is it is not different. It is not similar to any other laws that we have seen before. This is a techno-legal legislation. So here, before the legal comes into the picture, the technological requirements are captured in the law itself in a way that it's very difficult to, I mean, there is no violation aspects that comes once you start following the technological aspects. So privacy by design is something which is not said anywhere in the Act, but it is embedded in the Act itself. So when you design, for example, when you look at a car or a vehicle which has onboard diagnostics or which has cameras, 360-degree cameras, or maybe a camera which is facing the inmates of the car. So the camera should be capturing the data in such a way that the facial features are not captured, the voices of the people in the car are not captured. So you have to design the product in such a way that all these personal data are eliminated at the first instance itself. So this is not a new thing that is, I mean, we are faced with in the automobile sector. We have something called the Automobile Research Association of India, ARAI, which is a government instituted NGO under the Central Motor Vehicle Rules. And this organization has been functioning from a long time, and they are basically the organization which, if you want to bring a new vehicle from abroad and you want to sell it in India, so you have to go through the homologation aspects of ARAI, and then when it is passed, then you can sell that vehicle here, manufacture and sell the vehicle here. So that is what ARAI does. And what ARAI also does is, it also gives the technical regulations, like smallest things like what should be the color of the indicator, what should be the color of the bulb, what should be the brightness. So like this, there is something called automotive industry standards. So automotive industry standards of 149 and 189, these are standards which are applicable here in this privacy by design, and also the upcoming AI regulations. So we already are faced with this situation, but now DPDP makes it more hard. It is there to punish the violations if it finds any, and then it is not about just the paper compliance that we do for other laws, but we have to demonstrate the privacy by design aspect in all the activities, whether you're capturing the facial features, whether you're capturing the geographical location and you're sending it to the central servers located somewhere in the world. For example, the same onboard diagnostics of cars which are sold in Vietnam or Indonesia, you cannot send the diagnostics details anywhere across the world. You have to keep it in Indonesia itself, or you have to keep it in Vietnam itself. So that hard coding is there in those laws. But in India, we still have that leeway of you can transfer to the data to the whitelisted countries, but we have to ensure that the personal data is not transmitted. So it's a kind of a challenge that we are looking at. It's nothing new, but I mean, things are evolving very fast.
Thank you, Yogesh. And one of the things that I want to maybe a little later touch upon is how global corporations are dealing with this, right? Because part of the theme is also South Asia and how countries in this region are dealing with it. But challenges for global corporations like Volvo, as you rightly said, or GE Healthcare, where you really need to think about how data can move across borders. So we'll come back to that particular point in a bit. One of the things that I want to sort of get all of your views on, particularly the in-house counsels, is all of us, I think, have heard enough about the magic number of 250, right? Everything that has come up with respect to the DPDP Act, all people remember or take away from it is 250 crore fine, right? So that number has got embedded in the minds of people now. But coming back to my question, what I wanted to particularly get your views on is, where are you seeing areas where an organization can find itself in the crosshairs of the regulator, right? Where you're likely to be sort of, which is the most likely area to get you into trouble, under this law, whether it's 250 or whatever it is. And what do you suggest? I mean, we've got a lot of lawyers and in-house counsel in the room. What would you suggest are ways in which they can ensure that they're adequately protected, from the perspective of, I mean, I guess one can never say you're 100% protected from everything, but if you can minimize the risk to your organization, what would you say are 3 things that you could do? So where do you see the gaps that could likely cause an organization to get into trouble? And B, how can an organization plug that gap or remediate that piece?
No, I think Anthony, this is a very important question actually. So because see, obviously the DPDP Act started with a 250 crore bonanza, I would say. So in fact, the humorous part is that some of the kind of people are also saying is whether it's a fiscal legislation or it's a DPDP legislation. So now jokes apart, so basically see, I think to answer your question, there are 3-4 areas where basically the organizations need to be very mindful of. Specifically tech and fintech and all what I come from actually. So first and foremost, as I've already alluded in my previous point in terms of mapping. So the mapping has to be very absolutely clear. How you are apportioning the data is what you are receiving in terms of with which specific framework you have to map. How you are keeping a record of those mapping. What kind of consent what you have taken. Whether you are kind of assessing that legitimate uses based on your understanding or based on the requirements which has been given in Section 7 of the Act, that's a very important piece, because you cannot presume something, say like, okay, fine, this is for legitimate use, I'm not taking. Because the golden rule over here is, suppose Section 7 exemptions are not there. So the question would have been, like, if Section 7 exemptions are not there, then what would have been the thing? Would you still have taken that exemption? The answer would have been no. You would have taken a consent. So I think going ahead, consent would be more of a norm rather than an exception, irrespective, even if you're not clear of it exactly whether it's an exceptional thing or it's a consent based, you have to go by consent. So that's point number one. Point number two is the consent architecture actually. So what kind of architecture you have in terms of the entire process, whether you are reaching out to your third parties, your employees, your stakeholders, or whoever it might be, what kind of architecture you have made and all. So as far as the practical implementation part is concerned, one of the key things for our aspect is for the lawyers and in-house counsels is that what kind of robust contracts what you have with the third parties, whether you are embedding the DPA, the data processing agreement, into most of those contracts. Because the moment you take data, you become a data fiduciary. And this number of 250 crores gets directly applied to the data fiduciary. Now, irrespective of whether you process the data, you give that data to third party for processing, you have to be very mindful of that fact. So your contracting becomes very specific. Your liabilities and your all those indemnities and all those things should be clearly mentioned. Because unlike GDPR, you see data processor doesn't have any liability. In GDPR, data processors also have a liability embedded to them. They have to do the audits, they have to maintain those frameworks and all. So DPDPA does not talk about it. So eventually it comes to the data fiduciary part. The third part basically is from how do you deal with the data of the data principles. When you take that data, so whether you record it properly, you have the eraser mechanism, you have the consent mechanism, and how you're dealing with the data principles data, because that is one of the significant things upon which the liability would be imposed upon the data fiduciary. How you manage data principles data, that's the golden question. That's another important thing. The third one. The fourth one, obviously, as you have also mentioned about the localization part and all, because the law, if you see DPDP at this juncture now, it talks about the data is transferable unless it is restricted by Government of India. So it's a positive list.
Blacklisted. Yeah.
Absolutely. So that is one area we need to think. So like there are multinational companies. So basically either they have a mindset of following the standard contractual clauses, the SCCs, or that processes which were defined in GDPR. Now, if they have to kind of embed that as far as the DPDP Act is concerned, that they need to be mindful of how you are using the data, because if you are transferring the data at this point of time might be fine, but later on if there is any restriction by the Government of India, how they are going to deal with that. Whether they are putting in a cloud or where, on-prem and all those things, they need to be very mindful. So I think in terms of to answer your question, in order to challenge or prepare yourself from the 250 crore thing. So you have to see the mapping, you have to have a proper consent architecture, you have to have a proper localization norms, and you have to understand how this entire process, strong contractual agreements and all, that is the way you can safeguard your organization. Yeah.
Sounds like this law is a lawyer's dream. It's been made for lawyers, keeping Indian lawyers in mind, how to because everything that I think clearly we all agree and appreciate and understand that a lot of it boils down to how you interpret the law, B, then when you say contracting, right? Now, literally every contract you need to ensure that while provisions can be standard, but at the end of the day, there's also negotiations that happens in, and what goes into a contract, or how do you obtain consent? Again, the language of the consent needs to be vetted and approved by lawyers to say it's consistent with what the law is requiring of you, right? So it seems like this architecture really requires significant legal input in that sense for every company to operationalize. Yogesh?
So it's also important for us to understand as lawyers, we have to break down each of these activities in smaller components, and we have to ensure that granular consent is taken for these activities. I mean, legitimate use will not cover everything, and even a small part of the activity which is not related to the consent will not be covered. It's better to be, risk averse and capture the consent in a way that it applies to all those things. So this is one thing which stands out in this act. And what it also, there is a lot of work for the lawyers, but what opportunity it also presents is business opportunity wise. There are a lot of startups which can work around the DPDP itself and create business opportunities for themselves to MNCs or organizations which are not ready for all this smaller activity, breaking down of this consent architecture, or creating granular forms. So all these activities, or maybe even the data analysis that has to be done every now and then, every 3 months or 6 months, you have to do the data analysis to see what is the data, personal data which is sitting in your systems which are not bound to any consent. Or if you have to also see there should be a system which is running continuously to look at the expired consent, which is data with expired consent forms. So I think we have to be very much. This is just not a paper act. It is really something which will drag you down to the last point of your organization, and you have to look at it in a way that you have not seen the law before.
Basically, a lot of attention to detail in terms of where your data sits and how you've obtained the consent, what have you done with it, what is the period for which you're retaining, all of it. But technology can obviously play a significant role in helping us manage all of these aspects of compliance, right? Shivani, what would you say?
Yeah, so of course law is catching up, but as a technologist, I can tell you, because I sit in those discussions, right? The board that kind of discusses about what is it that we have to do to be compliant with DPDPA. And we have me as a cybersecurity expert, there's a privacy person who is actually a lawyer, because the privacy is now being handled by the legal people. And then there are others also. One thing which is very clear, at least for healthcare, right? You can have hundreds of contracts. You can transfer the brain to the legal department. You can transfer the ownership of data to the hospital. You can do everything that you can in the legal framework. But at the end of the day, if anyone suffers, it is the customer, right? It's the patient. And any healthcare organization works for the safety of the patient. You are serving someone who is one among us. So the technological controls that have to be there to be able to ensure that the device or the solution that a healthcare organization is providing is available at the time when the customer needs it, and not under an attack and not available, is something that drives us. And that is where technology is really important. You can have a contract where I tell that the hospital is responsible for it. You can have a contract where I say that data center is right here, so I'm good with it. You can have a consent management platform integrated, which is what I hear is Government of India is going to certify the the consent management platform. So you can go ahead and integrate with them and then transfer the ownership there as well. But accountability still lies with us, and that is exactly where the technology comes into place. So it's not only design, it's not only privacy by design, privacy, security by design, it is actually accountability by design. And that is something that is driving us. And those technology controls where if there is an attack going on, ensure that the damage is minimum, ensure that the system comes back in the least possible time, so that if the trauma patient is there on the bed, he is not suffering because your system is down because of an attack going on. What is your fallback mechanism? What is it that you do to get the system up and running in the least possible time? And what is it that you can do to minimize the damage? And those controls around it technologically is something that we are working on. And that is the importance of it. And with AI coming in, with solutions going on to cloud, what is that one big thing that is happening in the technology world is accountability by design. Whether law is there or not, whether AI governance is there or not, whether we are catching up with something or not, whether the country in which we operate has a privacy law by design or not, we are accountable to the patient. So the design, the technology that we are kind of developing has accountability by design. So we go through all the right processes, whether it's the AI governance board which is reviewing whether the algorithms or the models that we are getting in are good to go. We have red teaming activities to ensure that we are kind of simulating the attacks, and we are trying to prevent it to the most possible. Or it could be privacy reviews, it could be automating the process of complying to the privacy laws of this country in which it is being sold, or coming up with an umbrella privacy guidelines in the organization which will actually take care of all the different laws that are spread across the globe. So all of that is going on. I won't say we are there, or we are 100% there, or we are going to prevent all the 100% attacks. But technology is going to play a big role. And it's a very good time for AI enthusiasts, for people who can wear their thinking caps, right, to come up with the right solutions. Because technology is also evolving at a pace that we ourselves are catching up.
Yeah.
So it's important that the design itself of a product or a solution is done in a way that these aspects are taken care of from day one. And that is where the technology industry is trending towards.
Yeah, Debasish.
Yeah, just add 2-3 points, I think, what she is mentioning. See, one of the very critical aspects what you need to understand at this point of time is that the data privacy, the DPDP is not a individual discussion now. It has become a board level discussion.
Of course.
Because when we place it before
Because
our
of the
board
250 crore
committees and all,
number.
absolutely.
No,
So
it's not only
yeah.
the 250 crore. I'll tell you, it's also because the sophistication of the cyber attacks that are happening. And the nation state attacks, the sophisticated attacks.
But that was always part of your information security.
Absolutely.
InfoSec anyway was always part
absolutely.
of the conversation at a board level, even
Yes.
before DPDP.
Yes,
right?
yes.
DPDP has brought additional angles
Exactly.
to it, like consent
It's
management
just that
and
the
things like
privacy is
that.
also being discussed now.
Correct.
So basically, see, DPDPA is one part only. So even if an organization is entirely relying on DPDPA only to manage the privacy requirements, that cannot be the right way.
Yeah.
Because see, I'm just giving my example, and what she will also agree. Like, for an InfoSec team or a company like a sector like FinTech, they have to go through this ISO 27701, which is a PIMS, the
Correct.
privacy management information. You can have sectoral kind of privacy legislations. If you're operating out of Singapore or say US or somewhere else, you have the CCPAs or PDPAs of the world, which is getting applicable, or for the South Asian nations, what you're talking about. Third thing is that, like, if you're talking about this, if you're taking these discussions level to the board, you cannot simply say, like, I have done a policy, I have complied with my requirements and all. Because the understanding would be, if you are countering a penalty up to the tune of 250 crores, how robust your systems are, how it is in place, whether the legal, InfoSec, IT, all are on the same line. As she's mentioned about red team assessments, or in our case, like this PCI DSS standards, the Payment Council standards, and all the other standards which are applicable actually. How do you monitor the APIs? All those things actually becomes a discussion point before the board. So I think the board level discussion, the seeing the entire privacy legislation in its entirety, and how we are kind of operating at the ground level and taking it to the upper level, those are the critical features through which you can counter that menace of 250 crores or whatever, because see, 250 crore is the top one, because
Sure.
you have layered kind of penalty
It's
which
layered,
is there in DPDPA. So that is, I just wanted to add here.
No, thank you so
Yeah.
much for that. Yeah, Yogesh, you.
Just to add a point here, so this cannot be a bottoms-up approach. There cannot be a bottoms approach in complying with the DPDPA. It always has to be a top-down approach, because the kind of risk that is involved of penalty or losing a loss of reputation and all that. So it has to be a top-down approach, and the management has to see that a committee that reports to the management is always engaged in this activity or of deploying the DPDPA-related compliances, and it has to report to the board, because the first deadline that we are getting here in DPDP is the November deadline, wherein your consent management platform has to be ready and operational, and and it should be demonstrable that the consent is being taken, captured for all the activities, the logs, the deletions, so that hits in November. So the countdown starts from November.
Yogesh, staying with you, your industry in your industry, I think we're starting to now see connected vehicles, IoT and things like that, where you have a lot of data. You're actually collecting a lot of personal data of individuals, of drivers, of owners. At the same time, and I think the thinking is that you need to retain this data for a fairly longish period of time, right? To ensure, let's say, safety recalls, warranties, and so on and so forth. How is the thinking evolving within, let's say, the Volvo group, for example, in terms of reconciling this with, let's say, the requirement of the law, which is purpose-based, limit the usage, limit the amount of data you collect, and for the time period and all of those things. Are you able to put clear sort of barriers in place, or clear safeguards in place that says, okay, this is how long we keep it and this is how we keep it, or is that still an evolving conversation?
Yeah, it is an evolving conversation which is ongoing. So we should first remember that DPDPA says the data that you collect, you can keep it once the purpose is completed, then 30 days. And after that, you have to delete it. Unless there are other regulations which require you to maintain that data for a long period. We, operating in the automobile sector, we have something called 110 CMR, Central Motor Vehicle Rules of 110, wherein it speaks about recall of the vehicles. If there is a software defect or any kind of defect, the company should be able to recall the vehicle, and for that, we have to keep collecting the data, telematics data, and we have to retain it for you can say maybe almost the 6-7 years of midlife of the vehicle till the warranty period is over. So that was one thing that was which was there right from the beginning. But now there are new regulations called the Extended Producer Liability, Responsibility Regulation, in which the EPR regulations, it is popularly called. It was first applicable for batteries, then it was applicable for rubber, glass, plastic. Now it is applicable for the steel also. So the vehicle that you have sold 15 years back, you have to bring that vehicle back to the recycling system, recycle it, and use 8% of that steel in your fresh new vehicle. And this keeps increasing year on year. For a vehicle which is, 14 years old, then the percentage is more. So like this, you have to maintain the data for that entire period of the vehicle. The person who has bought the vehicle, his personal data should be maintained in the system. And maybe sometimes you may also have a question, faced with a question where, how do you locate the vehicle? How do you locate the vehicle? So at least for that 15th year of that vehicle, you have to switch on the telematics, switch on the location-related mechanism within the vehicle, and then you have to capture the location. So again, this is against the DPDP principles, as you
Could
might say.
you argue that this having to switch it on is because that is the purpose?
It's a purpose.
It's a purpose, and
It's a
therefore
legal
we have
purpose.
to. Yeah, it's a legal purpose, right?
Yeah.
And so we have to do it. And so
Exactly.
I suppose DPDP shouldn't be in conflict with DPDP from that perspective.
Exactly. And then we have autonomous vehicles where IoT, the cameras are constantly capturing the surroundings, the road counters, the traffic density. So all these data that is being captured, it is again being used in the system, and then proper alerts are given to the drivers of the vehicle. But fortunately for us, we have a lot of corporate customers. So personal data is not captured as, like for example, if you look at a two-wheeler manufacturing company, where individuals buy the two-wheelers for their personal use, and most of them are individuals, and then personal data is very high in that industry. So it is definitely a challenge. It is a constant evolving conversation, and then this is not just within the company we sitting and discussing with our engineering teams and all that. It is like the entire lobby of motor vehicle manufacturers sitting with the government, ARAI, and designing proper mechanisms to ensure that we don't violate the DPDP rules, or we don't seemingly violate. So that is one thing that we have to
So there's
ensure.
a lot of collaboration and conversations happening with the government to ensure that you're both aligned and on the same page with
Yes.
respect to compliance.
Yes, yes.
Okay.
Yeah.
Shivani, in your industry, the healthcare industry, right? You have so much patient data, right? Healthcare. I mean, I would have sleepless nights if I was in your industry, because there is so much data that you have. Yet there seems to be, I mean, HIPAA and GDPR and all of these different statutes that you're required to comply with. And then do you find that DPDPA is putting you in a conflict with the other statutes from the perspective of retention of data, or are you finding that you're able to harmonize it and say that actually, no, it's fine and we are able to sort of take everything together?
So it's not as straightforward as as I can say that no, since we are complying with GDPR or HIPAA, we are good. There is a issue, because here they are saying that you have to mention everything that you're taking the data for in the consent management, right? You have to mention everything. Now healthcare is a very dynamic sector. When you collect the data, the person has just come to visit for his headache. Now the headache could go to a neurologist, it could go to an OT, or it could happen. Anything can happen there, right? Now, how exactly are you going to manage that consent? So I'll just give you a small example of something that happened in the US, which we can relate to here, right? So I was just thinking about it when he was talking. So we have a CT scanner, right? CT is nothing but X-ray in a higher dosage. So you should go for a CT only when it is really required. Nowadays, I see that the doctors just write that, okay, get a CT done. It's not that good. You should always be careful before you go for a CT. The benefit of getting a CT done should exceed the problems that it can bring in, because it's an X-ray and it's just an advice. So what happened was there was this CT scanner. This person gets a CT done, and then he gets treated. He comes back home. He's all good. This happened like 8-9 years back, and then he comes back home, and he's all well. There's some six months down the line. He sees an ad on the TV where they say that, are you suffering from hair fall? Do you think your skin is more some itchy or whatever? It could be because you've been subjected to higher dosage of X-ray. And in US, if you would have visited these kind of ads that law firms put, right? So, and this law firm says you can reach out to us. And this person says, of course I'm seeing hair loss. Of course I'm seeing the skin condition a little bit. He goes and reaches out to the law firm. Now the law firm says, oh, looks like, and then they dig back. And it's like 8 months back, this guy had gone through some CT for some condition of his. And he got treated and everything done. He's good now, but he has some hair loss and something. And then some health checkups are done after that, and he is good. He's not into some severe situation or whatever. But he files a case that this particular CT scan that I got done, I think the dosage was more than what was needed to treat my illness. And I think the hospital is responsible. Now the hospital says, and then they get into the court, and the hospital says, what can I do? My device manufacturer gave me some predefined protocols. I used one of them. So if the person has come for a stomach scan, in our scanner we tell, if it is stomach, you can select this. If it is lung, you can select this. So the device itself will decide the dosage and all of that. And you can edit it based on your hospital's protocols and all, but they didn't edit or whatever that was. So now the case included
device maker.
the manufacturer
Oh
also.
God.
Right? And the manufacturer finally went ahead and was able to prove that it was a default protocol, which we explicitly mentioned that it is default. It's not our fault. They should have changed it. It is written clearly there that you have to change it. They didn't do. See, the lawyer saved our day. But then there was this person who suffered, which is one thing not good. And I'll tell you, we technologists had to go through an effort which was an year of work for almost 20 teams to come up with something called as, we will decide on those protocols, and we worked with the radiologist to decide on the correct amount, dosage of X-ray that should go. And we will create those protocols on the cloud, we'll keep it there, and then these hospitals can pull that, so that they don't end up in this situation if the technologist in the hospital is not trained well, because he will just use whatever is default. See, these are the situations. And now this is US. Now think of India. US has a lesser population, their throughput is very less in the hospitals. I visited one of the hospital as G in US, and the throughput is so less. And in India, on a CT scanner, it's like an X-ray. There is a queue. There will be people, and so think of it, how you can think of training your technologist, how you can train him on what is that X-ray dosage that he has to give, where he has to pull from, whether he knows cloud and all of that. So that is the biggest challenge for us. You can have all the technology guardrails placed or the legal guardrails placed, but the diversity that we have in our country, there are people who don't understand anything, there are people who are completely aware of everything, and that gap is very huge. So healthcare caters to all this dynamic group. So for us to be able to comply with or to be able to serve this entire dynamics with our device being sold into a diagnostic center, which is a very small one, which manages only CTs, to a big hospital chain, which has in itself 10 CTs, right? So that dynamism and that diversity is what is giving us that sleepless nights, because one is completely aware, so doing everything right, the other doesn't know anything, is misusing, and at the end it could be us who will be brought into that, right? Correct. So that brings a problem for us. But along with it, as I told you, right, the new thing that we technologists are talking about now is accountability by design. We are accountable to the end customer, whether legal is guarding us well or not, whether we are having the right contracts with the customer or not, whether the patient has given consent or not. All of that is one side of it, but when we are designing, do we want to be at that table on the software that we have written is something that drives us, and I think all the technological guardrails are being designed with that kept in mind.
Thank you, Shivani. Debasish, I just want to sort of come back to something we had touched upon briefly, which is, for cross-border data flows, the GDPR approach is whitelisting, and the DPDP approach is sort of blacklisting, which means, in a sense, everything is okay until blacklisted, right? And, from your perspective, which, if you can just share with us, what do you believe is a better approach, or do you think that this blacklisting approach works because from an Indian perspective, it's better keeping in mind where we are and, how we operate. It's better that everybody's able to sort of do what they need to do until told otherwise, So your thoughts on that?
Yeah, see, Anthony, what I feel, probably there can be a scenario where we can take horses for courses kind of an approach. some of the significant and most important data, so the financial data or healthcare
Yeah.
data and all those kind of data, I think there has to be a very clear thought process around it, because until and unless it is something which the overseas regulator or any specific authorities are asking for it, you should not share. And that is the approach what RBI has taken in terms of the financial data. Through their 2018 5th June circular. And they have made it very clear, like if it's for any regulatory purpose or if any investigation or purpose, then you can share, but otherwise not. So I think one has to be mindful. Sensitive data, something which, because as you see, irrespective of how many data privacy legislation or privacy legislations what you can have globally, but the moment you share those sensitive data and all, so obviously there is a higher probability of getting those data leaked here and there. And also I think on those data there has to be a proper, as you have rightly mentioned, of the blacklisting, but some other data actually. But what the government is saying is like, see, the data is freely transferable unless we kind of restrict it through other. Absolutely. Yeah. So we can have an approach for those non-sensitive kind of data. But for sensitive data, I think there has to be a proper blacklisting. That's the way I look at it. And in fact, like, see, if you see, in a very interesting thing, I was looking at it a few days back. We were kind of surveying around 190 countries. Yeah, I'll just few seconds. So we were kind of doing survey for 190 countries where we were trying to see like how we can approach and like how our payment system mechanism can do. I found a lot of countries, they don't have a data localization norms also. Even countries like Australia, they don't have a data localization kind of a thing. So yeah, it's based on that. But yeah, coming back to my point, so I can have a horses for courses kind of an approach here.
Wonderful. In which case, since we are almost out of time, I thought we could end with a maybe quick rapid fire for each of you, which is basically, you know, as let's say your CEO is asking you, right, give me one thing that I need to do on highest priority to ensure that we kickstart or we focus on DPDPA compliance in a way that protects my organization or our organization the best. Just one. Very quickly around the room. Maybe we start with you, Debasish.
Yeah, from data compliance to data governance. So the days of compliance are over. Now we have to see how we are governing those data. I think that's the suggestion what I'd like to take it here.
Okay, very good. Thank you. Yogesh?
Yeah, from my GDPR point of view, I would say the blanket consent days are over. So we have to look at granular consent and we have to start with the consent first. Consent first. Okay, wonderful. Thank you.
So as a technologist, I would say we have to invest big time on AI governance.
AI governance. So that's the first thing and
Because
very important thing that you need to focus on right now.
Yeah.
Okay, wonderful. You've heard three different responses from three different professionals, all having their own perspective. But thank you all so much. It's been a wonderful conversation. Thank you very much. Do we take questions now? Or we don't have time for questions?
Thank you all our brilliant panelists. I would request everyone to please come forward for the group picture of the panelists.